I'm Jason English, founder of Jason English Law. I'm a former prosecutor who now represents good people who are facing criminal and drunk driving charges. One thing that I'm often asked is, hey, the police didn't read me my rights. And what does that mean? We're going to talk about that more today. The police didn't read my rights. Will the charges against me be dismissed? You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to have an attorney present during the questioning. If you cannot afford an attorney, one will be appointed for you at public expense. These are the so-called Miranda warnings. Law enforcement must give these warnings before conducting what's called a custodial interrogation. This means that if you're in custody, officers must advise you of your constitutional right to remain silent and right to counsel before they question you. To put it another way, if you're not in custody at the time of the interrogation, then no warnings are required. This begs the question, what does it mean to be in custody? You do not have to be arrested or questioned at the police station or confined to a jail cell to be in custody. Rather, the law says that you are in custody anytime you're deprived of your freedom of movement in a meaningful way. This is an objective standard, so the question is, considering all the circumstances, would a reasonable person in your shoes feel free to end the police questioning and walk away? If not, then you're in custody, regardless of where the questioning takes place, and the officers are required to advise you of your rights. So what happens if they don't? What remedies are available to you if the police conducted a custodial interrogation without advising you of your rights, as required by Miranda? In that instance, you and your defense attorney can file a motion to have your statement suppressed because it was obtained in violation of your constitutional rights. If a judge agrees and grants the motion, then your incriminating statement cannot be used as evidence against you at trial. Your statement is suppressed, effectively tossed out and off limits to the prosecution. The impact of a suppression motion can be huge. If the prosecution's case hinges on your incriminating statement, then suppression of the statement might lead to a more favorable plea offer or possibly the dismissal of the charges altogether. But don't count on that. Suppression motions are fact specific. Regardless of how you perceive the encounter with the police, you can bet that the prosecutor will argue that you were not in custody or that you were not being interrogated at the time you volunteered the incriminating information. Because reasonable minds can differ, it's not always easy to predict how a judge will rule on a suppression motion. Bottom line, rather than hoping that the police will make a mistake and a judge will suppress an incriminating statement, the best thing that you can do when being questioned by the police about suspected criminal activity is exercise your Miranda rights. Say to the officers, I wish to remain silent. I want to speak to my attorney. Then remain silent until your attorney arrives. Granted, this is not easy to do. We understand that. If you confessed or made other incriminating statements to law enforcement, reach out to us. We can help. In addition to Miranda violations, there are numerous possible grounds to challenge the admissibility of statements made to the police. Let's talk about your situation and review your legal options.